guys, my name is Joel Williams. I'm a personal injury attorney in Kennesaw, Georgia. This is going to be the first of a series of videos primarily geared towards attorneys and fellow members of the bar dealing with more technical legal issues that I hope will be helpful to you in your practice. I understand that some of you do not practice personal injury law, so from time to time I'll have guests come in and speak on various issues dealing with maybe family law, wills and probate, criminal law, property law, that kind of thing. So that it will be beneficial to all different practice areas. If there's anything in these videos that you disagree with, or if you want to expound upon it, we'd encourage you to like our video on our YouTube channel, or just leave a comment in the comment section below. And hopefully any comments that you leave will be helpful to our fellow bar members. But today, I want to talk to you about a legal defense that we often see in premises liability, personal injury cases, and sometimes construction defect cases, and that's called the acceptance doctrine. So the case that we see cited most often by defense firms when they're defending a premises liability personal injury case or a construction defect case, and they raise the acceptance doctrine, is Smith versus Dabbs-Williams Contractors. Smith versus Dabbs-Williams General Contractors is a 2007 Georgia Court of Appeals case, 287 Georgia App 646, and it sets forth the general rule. And it says that the long-established acceptance doctrine provides that where the work of an independent contractor is completed, turned over to, and accepted by the owner, the contractor is not liable to third persons for damages or injuries subsequently suffered by the reason of the condition of the work, even though he was negligent in carrying out the contract, at least if the defect is not hidden but readily observable on reasonable inspection. So first and foremost, if you're asserting the acceptance doctrine defense, you want to try to prove that the work that was done by the contractor was not negligent. But sometimes this is often going to be a jury question, and the court will decline to grant summary judgment just based on that. However, there are situations where the court will grant summary judgment based on that, and the perfect example is Bragg versus Oxford Construction. That's a case where Dougherty County hired Oxford Construction Company to repave a road and fix some potholes and things like that, and Oxford Construction did everything the county told them to do. The work was not defective, and Justice Melton, in the opinion he authored, said that because there's no evidence that Oxford performed the assigned work in a negligent manner, it cannot be held liable for injuries resulting from its employer's allegedly defective design of the work. So first and foremost, the thing that you have to prove is whether or not the work performed by the contractor was negligently done. The next thing to consider when determining how you're going to try to overcome an acceptance doctrine defense is whether the defect was readily observable on reasonable inspection or whether the defect was hidden. And there's a case from the Court of Appeals from 2014, and it's called Ganesh Lodging versus Smith, and the site is 328 Georgia App 713. In that case, a person who was building or renovating a hotel hired a contractor to come in and compact some dirt, and the contractor did not compact the dirt properly, which resulted in portions of the hotel, I think maybe a swimming pool, was starting to sink once the dirt began to give way. And the Court of Appeals looked at that in the face of an acceptance doctrine defense and said that it was not susceptible to summary judgment because the defect was hidden or not readily observable on reasonable inspection because it was under the ground and the owner could not easily find the defective work. Another interesting fact in the Ganesh case is that the Court of Appeals seems to indicate that in a situation where an expert may be needed to discover the defect or to appreciate the defect, questions of fact may remain for the jury's determination as to whether the defect is readily observable on reasonable inspection. The perfect example of this is in Clive versus Gregory. The site is 280 Georgia App 836. In Clive versus Gregory, the Court of Appeals reminds us that a plaintiff may not recover for injuries caused by building construction defects which were discoverable upon reasonable inspection. In that case, the homeowners hired a contractor to come out and do some work on their home and to build a barn. and the contractor did not properly brace the barn as required by county code. But the homeowners had no knowledge of county code. They relied on the expertise of the contractor to do this. Well, the wife, one of the plaintiffs, was beside the barn when a strong wind came by, it blew the barn down on top of her, and she was injured because the barn was not properly braced. Now, the interesting fact here is that the Court of Appeals tells us that if the plaintiff cannot appreciate the defect or the hidden danger, even though it may exist, then questions of fact remain for the jury as to whether the defect is readily observable on reasonable inspection. And in that case, the jury did get to decide, or at least the Court of Appeals sent it back to the trial court and said the jury should get to decide whether this defect was readily observable, but more importantly, whether, even though the plaintiff could see it with their own eyes, whether they appreciated the danger that they were looking at. So to sum this up, we have to remember that the acceptance doctrine only applies if the work is not negligently done, and also it only applies if the defect is not hidden but readily observable on reasonable inspection. Now, just like any rule, there's always exceptions to the rule. Sometimes the devil's in the details. But as far as the acceptance doctrine goes, there are two exceptions if the defect is readily observable or if it's not hidden and there's negligence. Some people think that that's the end of it, but it's not. There are two exceptions to the rule, and the two exceptions are this. If the work is a nuisance per se or inherently dangerous, then the acceptance doctrine does not apply. And if the work is so negligently defective as to be imminently dangerous to third persons, the acceptance doctrine does not apply. Now, of these two exceptions, the most commonly litigated of the exceptions is whether the defect is inherently dangerous or imminently dangerous to third persons. And the perfect case to demonstrate this exception is Hollis and Spann versus Hopkins, which is a Court of Appeals case from 2009. The site is 301 Georgia App 29. In Hollis and Spann versus Hopkins, a contractor contracted with a hotel to build a handicap access sidewalk, one of those with the ramps that lead into a facility. And the contractor built the ramp in such a way that the flared sides were too steep. In other words, they weren't code compliant, and the plaintiffs were able to show this. And because the plaintiffs were able to show this, the court held a genuine issue of material fact also existed as to whether the constructed ramp was so negligently defective as to be imminently dangerous to third persons, bringing it within the exception to the rule. The court went on, prior precedent shows that a handicap access ramp, similar to an escalator or staircase, can be dangerous to third persons if made or installed in a negligently defective manner. So when we look at that, if we're dealing with a handicap access ramp or stairs or an escalator, things of that nature, if they're not built properly or if they're outside of code, then there's a jury issue as to whether they are so negligently defective as to be imminently dangerous to third persons. Okay guys, I hope that information on the acceptance doctrine and its exceptions have been helpful to you. If you have any additional insight, again, please just put a comment in the section below on our YouTube channel. Or if you disagree with anything that's in here, then I'll be happy to talk to you about it. You can call me at 404-389-1035 or email me at joel@gatrialattorney.com. We look forward to doing more videos for you. If you have any ideas, things that may be helpful to other members of the bar, please let me know and we'll do our best to get some information out on those topic matters. Thanks a lot.